Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Inat Kudi bin Muhammad Zaidi. My matrix number 14DAT20L1043. And my friend Muhammad Anif Alim bin Haris Fazilal. And the matrix number 14DAT20L1028. And Farid Elmi bin Tajuddin. The matrix number 14DAT20L1034. We like to present about case study of company law.
Okay, the answer for this question is the issues of the case Millennia Group versus Rahul and Associates, whether Millennia Group can sue against Rahul and Associates. So I would advise Millennia Group not to take a legal action against Rahul and Associates. So according to section 287 in bracket 3 of Companies Act 2016, an auditor shall not be liable to be sued in any court or be subject to any criminal or disciplinary proceedings for any report under section 266 submitted by the auditor in good faith and in the intended performance of any duty imposed on the auditor under this act. So the case which is related to this question is Candler versus Crane, Christmas and Co. Can I ask the issues for this question is, could the accountants be liable for the negligent preparation to the third party for their loss?
Okay, Bismillahirrahmanirrahim. So now is fact. Okay, fact. Donald Ogilvy was the director of a company called Three Bowness Hydraulic Tin Mine Ltd, which mine tin in Cornwall. He needs more capital, so he placed an advertisement in the Time on 8 July 1946, which read 10,000. Established tin mine, low capitalization in Cornwall, seek further capital. Install additional milling plant. Directorship and active participation open to suitable applicant. Apply. Candler responded, saying he was interested in investing 2,000. Provide he show the company account. So, Ogilvy instruct Crane, Christmas and Co. of a firm of auditor to prepare the company account and balance sheet. The draft account were shown to Candler in the presence of the auditor clerk, Mr. Fraser. Candler relied on their accuracy and subscribed for 2,000 worth of share in the company. But the company was actually in a very poor state. Ogilvy used the 2,000 on himself and then bankrupt. Candler lost all the money he invested and brought an action against the accountant, Crane, Christmas and Co. Okay, for negligently misrepresent the state of the company, as there was no contractual relationship between the party. No case arose in misrepresentation, and so the action was brought in tort for pure economic loss.
Okay, next is decision. Court of Appeal give judgment that Crane, Christmas and Company are not liable for the loss. This is because there is no breach of contract. Therefore, there is no duty. Other than that, Lord Deneen desisted, saying there could be a duty if the accountant knew of the transaction investing, which would result from their statement. In this case, they were present at the time the defendant decided to invest. So, the firm of accountant was not liable to outsider investor who had relied on negligently prepared report, because there was no contract between the accountant and outsider, and they were under no duty of care. Okay, next is conclusion. If Millennia Group take legal action against Rahul and associate, they cannot be sued because according to section 287(3) of Company Act 2016, auditor cannot be sued by outsider because they are not liable for them as there is no contract between them, and the auditor own a duty only to their client company and not to a outsider.